So she says, thanks for the info. It is much appreciated, but could you please advise me with regards to what you would need in order to successfully apply for a spoliation order? How long does the process take? And which course of action is easier, more effective, and least time consuming between the tribunal and the sheriff of the court? This would be very helpful. Thank you.
I'll break it down into a couple of sections and I'll try and make sure I don't do too many legalese. So the first sort of element there was, what do you need for a successful spoliation order? Now, luckily, spoliation orders are very simple things to get in law, and they kept simple for a good reason. So that old adage, possession is 9/10 of the law. This is what we're talking about right here, all right? The only things that you need for a successful spoliation order is you need to demonstrate that you had possession of a particular thing and that that possession was taken away from you by an unlawful means. And by that, we mean without a court order in place, okay, or some sort of order in place. Those are the only two elements that you need. If you can demonstrate both of those, then you are entitled to a spoliation order. And in granting a spoliation order, you simply get placed back in possession of the thing that was taken away from you, okay? So those are the elements you need for a successful order. As for the rest of the question, so they sort of tie into one another. How long does it take, and what sort of forum do you approach in? So a spoliation order by its very nature is an urgent matter, okay? So when possession of something that you have is taken away from you, you are entitled to approach a court on an extremely urgent basis to have that thing returned to you immediately, okay? And it's one of those orders that you can approach a court on an urgent basis, and there are sufficient grounds for you to do so. So when we talk about approaching a court on an urgent basis, generally your courts are going to have a period from a Thursday to a Tuesday during a week where you must bring your urgent application. There are abilities for you to bring it on an even more urgent basis than that, but you must supply the court with good grounds for doing so. So in circumstances, for instance, where you are locked out of, say, your home, okay, there are very good grounds to adverse to a court that, you know, you should have it on an even more urgent basis than your normal Thursday to Tuesday roll. But again, it depends on the particular matter. As for the forms, so really, the primary way of doing this, we would always suggest is a court of law, okay? The tribunal was given certain powers during the national state of disaster to handle these issues. But actually, Bruno and I had a little bit of an argument just before this to see whether they actually still have that power in the circumstances, because it was part of the disaster management regulations, and they were extended when the national state of disaster came to an end, but only for a period of 30 days. So whether they still have that power, we actually need to do a bit of research just to check. But courts will always have that ability, magistrates and high court, to do a spoliation order, and they do it on what I would assume would be a much quicker basis than the tribunal would do it in any event. So really approach your courts in the circumstances where you have a case for spoliation.
So Nick, interesting question. And I experienced this with a couple of magistrates' courts, and I found it quite unfortunate, but not entirely surprising. Some magistrates' courts make it so easy for occupiers to get spoliation orders that they literally have a fill it in yourself form.
Yes.
That you occupier can walk in, fill it in, and they get accompanied to a magistrate. Magistrate seemingly stamps it, just rubber stamps it, because some of them, the barely information gets given, it gets served on the landlord, and sheriff now goes to execute. But yet an attorney goes to acquire a spoliation order, and we got pushback on our attempts in some courts to do it ex parte. The same way, so ex parte, for the sake of the viewers, is so spoliation orders are brought, like Nick said, on an urgent basis. But so a lot of the times you can get away with it on an ex parte basis. That basically means you approach the court without giving notice to anyone else. You get an order right now, and this order can be disputed, say, tomorrow, right? So it's a sort of thing where you get a temporary order, almost get the benefit of the doubt, so that everything's restored to you, and then tomorrow people can come and fight on the facts of the case. And as on some of the cases we went to court on, where we tried to approach the magistrate ex parte, they told us they wanted notice and they wanted it brought before open court. Whereas occupiers that go there directly, they're willing to give these orders without notice to anyone. Have you experienced the same thing?
Yeah, so unfortunately we have, and I think it just comes down to, occupiers who are applying themselves without legal representation. Obviously, the court gives some level of leeway. The thing with that I always do, and I do expect to see in all urgent applications, it's a general rule that your urgent applications should never be final relief. Certainly when we do urgent applications, we always try and have what's referred to as a Part B. So a Part B that's going to be heard in the ordinary course that actually dissolves the dispute. But your Part A is your spoliation, which is brought on a very urgent basis. And yes, as attorneys, we get the the magistrates directing us very strictly on how these things do. And I do think that your occupiers get a bit more leeway in the circumstances. You'd hope, obviously, even if those orders are granted to the occupiers, that there is some level of Part B that's going to be heard in the ordinary course. But, these things do happen. And I think they do get a little bit more leeway, than us attorneys who are expected to follow the rules to the T, even in the urgent proceedings.
So I suppose from our perspective, if it's not a complex case, it does actually make sense for an occupier to approach the court themselves if they've been dispossessed, and then bring in an attorney at a later stage if it gets disputed. But you're probably better off getting the relief as a layperson as opposed to with the legal advisor.
It's possible to do, and I do know a lot of courts do, as you say, have standard forms that can be used, and the registrar or the clerk at the court does assist them in the circumstances. But again, you're right. It does depend on the particular facts of that particular case. You don't want to be, an occupier who's approaching the court, and then whoever has spoliated you pitches up with a heavy hitter attorney who's going to take you out because you on a formality or something to that extent. Exactly. You do need to be careful because, if you have someone who spoliated you, it's possible that they do that to the surface.
Sure, absolutely.